In this country, and in Indiana, all criminal defendants have important constitutional and legal rights. Please listen carefully while I summarize some of those rights, and as I explain the possible penalties you face and the procedures that we follow. You have the right to a public and a speedy trial by jury. You have the right to face and cross-examine witnesses who appear against you. You have the right to compel witnesses by subpoena to appear and testify on your behalf. You have the right to remain silent. You can't be compelled to talk with the police or testify at trial. If your case goes to trial, the state must prove beyond a reasonable doubt that you committed the offense charged before you could be convicted of that offense. If you are found guilty at trial, you have the right to appeal your conviction to a higher court. You have the right to be represented by a lawyer at all stages of a criminal proceeding, including the appeal. And if you can't afford a lawyer at any time, this court will appoint a lawyer to represent you at public expense. If you go to trial and you're convicted, these are the maximum penalties that you may face. For a Class A felony, 50 years in prison. A Class B felony, 20 years in prison. A Class C felony, 8 years in prison. A Class D felony, 3 years in prison. A Class A misdemeanor, 1 year in jail. A Class B misdemeanor, 6 months in jail. A Class C misdemeanor, 60 days in jail. In addition to jail or prison, all felonies include a fine of up to $10,000, and a Class A misdemeanor may include a fine of up to $5,000. A Class B misdemeanor may include a fine of up to $1,000, and a Class C misdemeanor may include a fine of up to $500. In the event of a conviction at trial, the following are the minimum penalties that you would face. For misdemeanors, the court may impose no jail time or fine. However, the minimum penalty for a Class A felony is 20 years in prison, a B felony, 6 years in prison, a C felony, 2 years in prison, a D felony, 6 months in jail. The law requires that the minimum penalty for most Class A felonies must be executed. The law generally provides that the minimum penalty for all other felonies must be executed when you have a prior, unrelated felony conviction, certain prior juvenile adjudications, or if you are convicted of committing a felony while you're armed with a deadly weapon. Otherwise, the court has the discretion to execute all or a portion of your sentence or to suspend all or a portion of your sentence. If you are convicted at trial of a Class D felony, you may ask the court to consider reducing that felony to a Class A misdemeanor at the time of the sentencing. The court may consider that request only if you have never had a felony reduced to a misdemeanor before. There are other important considerations that affect the outcome of a criminal sentence. First, a prior juvenile record or a criminal history may aggravate or increase the penalty within the range allowed by statute. Second, when a defendant is found guilty of more than one offense, the court may sometimes impose the maximum penalty on each crime and order that those sentences be served consecutively. Third, if you commit a criminal offense while you are serving a suspended sentence or while you are on probation, parole, or on work release or other community corrections, that privilege may be revoked and you may be required to serve the original sentence in prison. Such a revocation is likely to be served consecutively to any jail time on the new criminal offense. If you have a plea agreement, you should also know that the court is not a party to any plea agreement that you may have negotiated with the state of Indiana. I will decide later whether to accept or reject your plea agreement. If I accept the agreement, I am bound by its terms. If I reject the plea agreement, a not guilty plea will be reinstated and we will reschedule your trial. At the trial, neither your guilty plea, the plea agreement, nor any pre-sentence report from probation would be considered as evidence in the case against you. In a few minutes, I'll have a personal conversation with you to be sure you understand the charges against you, the legal rights I've outlined, and the possible penalties that you face. If you are here to plead guilty, I'll also want to be sure that your plea is made freely, knowingly, and voluntarily. And if your guilty plea is pursuant to a plea agreement, I will ask you questions to be sure you understand the terms of that plea agreement. Always discuss with your lawyer the rights you are waiving by pleading guilty and any particular rights that you may be waiving, including appeal rights in your particular plea agreement. Finally, if you plead guilty without a plea agreement, or if you plead guilty pursuant to a plea agreement that gives the judge some discretion or a range of penalties at sentencing, you may still appeal the sentencing decision, unless you have waived that right as a part of your plea agreement. However, any sentencing appeal must be filed within 30 days of the sentencing date, or the right to appeal will be waived. Thank you for your attention to these important matters.